If you don't yet have a seat, hopefully they're going to bring some more chairs in and fill. Yes, I've been given the signal. There'll be more chairs brought in the back. This is a fabulous turnout, and we're really pleased to see all of you. I'm going to turn this over to Dean Martin Brinkley to kick us off, and then I'll be back up here to introduce our speakers.
Thank you very much, David. It's my great honor to welcome you to Chapel Hill on what is truly a Chapel Hill day. That sky today, after the weather we had over the weekend, was very special, and I'm so glad you all are here, and thank you for taking the time and trouble to join us. We're delighted with this turnout and know this will be a wonderful program. The Wade Hargrove Media Law and Policy Colloquium is a joint program of our Center for Media Law and Policy, which in turn is an interdisciplinary center maintained by both the Hussman School of Journalism and Media and the UNC School of Law. And I particularly want to recognize my new decanal colleague, Raul Rice. Raul, where are you? Here in the front row, and you'll hear from Raul. Stand up, Raul. Delighted to welcome Raul to Chapel Hill as the new dean of the Hussman School. The Hargrove Colloquium was established in 2009 to honor a figure of national prominence in the areas of media law and media policy. And it was funded in part by the North Carolina Association of Broadcasters and the North Carolina Cable Telecommunications Association, to recognize the more than 3 decades of service rendered to those organizations by Wade Hargrove, a graduate of UNC Chapel Hill, class of 1962, and of the UNC School of Law. I have known Wade for many years, as I know many of you here in the room have, but I wanted to share with you or just remind you of a couple of things about Wade you might have forgotten. Wade came here to Carolina and majored in something called radio, television, and motion pictures, which my wife Carol, who also is a graduate of the Hussman School, told me that RTVMP was still a major at the time that she was here in the 1980s. Wade has been a remarkable servant of the university. He served as chair of the Board of Trustees for a term beginning in the year 2011, and also chaired, I believe, the search committee for Chancellor Carol Folt at that time. So Wade has given exemplary service to this institution. He has been president of the Law Alumni Association, and we all treasure him. And Wade, it's really a joy to be here in your presence tonight, and thank you for being with us. I want to congratulate David Ardea and Amanda Reed. David is my colleague at the School of Law. Amanda Reed is a faculty member at the Hussman School, and they are the co-directors of the Center for Media Law and Policy here tonight. And I believe did I see Kathy Packer here earlier? Is Kathy here? Maybe not. I thought I had seen Kathy, an earlier co-director of the center from the Hussman School. Lastly, cannot leave this podium without saying that you are going to have the total joy of hearing a program moderated by the most wonderful associate dean any law school dean has ever had in the history of the country, and that is Mary-Rose Papandrea, who served me for 5 years as my associate dean. I'm forever indebted to Jack Boger, my predecessor, for hiring her. She is an absolute star and joy, and she will bring us Floyd Abrams as no one else could. So thank you so much, Mary-Rose, and thank you for letting me offer this introduction, David.
Well, I should have Dean Brinkley always do introductions. He is just fabulous, and thank you for that kind and gracious introduction. And I also want to thank Wade for inspiring the creation of this colloquium series. for having the vision to demand that the law school and the journalism school create a Center for Media Law and Policy, which brought me down here from Boston, and then eventually brought my wife, Mary-Rose Papandrea, 4 years later. You'll get to hear from her in a moment. And for his unfailing enthusiasm and support for the center over the years. Thank you, Wade. It's my great pleasure to introduce to you our colloquium speaker, Floyd Abrams. But before I do so, let me tell you a little bit about the format for this evening. In addition to speaking about the future of the First Amendment, Mr. Abrams has graciously agreed to sit down with Professor Mary-Rose Papandrea, the Samuel Ashe Distinguished Professor of Constitutional Law at the UNC School of Law, to discuss in greater depth these really important issues that are raised by the First Amendment in our society. We are very fortunate to have Professor Papandrea with us this evening. In addition to being an influential First Amendment scholar in her own right, she is known for her expertise on issues of national security and government secrecy, having served for the past 10 years on the editorial board of the Journal of National Security Law and Policy. She's also been deeply involved with student speech issues and recently stepped down from leading the university's Promote Democracy initiative. This past spring, she taught the nation's first law school class focused exclusively on free speech issues arising in the educational context, both K through 12 and higher education. If you've been following the news, you know that that is a very important issue. Mary-Rose is also the former chair of the Association of American Law Schools Media Law and National Security Law sections and is a frequent commentator in the press, as well as a moderator and panelist on a whole range of CLE events, including, many of you may know her from the Carolina Law's Festival of Legal Learning, where she lectures to a packed room of lawyers and also serves as the faculty director. Let me also add that I've watched Mary-Rose and Floyd together over the years, and they have quite a rapport, which I think is going to lead to a really great conversation. So we are planning to hold time at the end for your questions. If you do have a question, we'll ask you to queue up. There's a microphone in the back there, and Mary-Rose will give you the signal when it's time, but hopefully you'll already have some questions when you arrived, but some will be prompted by the conversation. And please note that we are recording this colloquium, and so if you do ask a question, you'll be part of that recording. Now let me tell you a little bit about our colloquium speaker, Floyd Abrams. So Floyd graduated from Yale Law School in 1960 at the start of what turned out to be a pivotal time in the development of the First Amendment law. In 1964, in New York Times v. Sullivan, the Supreme Court constitutionalized the law of defamation, concluding that for a public figure to win a libel case, they must prove that the publisher acted with actual malice, meaning that they knew the information was false or acted with reckless disregard for the truth. In 1969, the court decided Tinker v. Des Moines Independent Community School District, where the court said that students have a First Amendment right to express political opinions in school, as long as that expression does not substantially disrupt the educational process. In that same term, the court decided Brandenburg v. Ohio, where it ruled that even speech advocating illegal conduct is protected under the First Amendment unless the speech is likely to incite, quote, imminent lawless action. Now, why do I mention those three cases? Well, I expect that we're going to hear more about those cases tonight as their holdings continue to generate controversy and as the current court seems inclined to revisit established precedents. So after clerking for Judge Paul Leahy of the U.S. District Court for the District of Delaware, Floyd began his legal career as an associate at the New York law firm of Cahill Gordon Reindel. He quickly became known for his expertise in the First Amendment law and in fact played a key role in many high-profile cases involving the First Amendment, including New York Times Company v. United States, otherwise known as the Pentagon Papers case. So in the 1971 Pentagon Papers case, Floyd represented the New York Times and successfully argued that to the U.S. before the U.S. Supreme Court that the government's attempt to block the publication of classified documents related to the Vietnam War was a violation of the First Amendment. This decision established an important precedent that is taught in every class on the First Amendment and cemented the young Mr. Abrams' reputation as one of the nation's foremost First Amendment lawyers. Only a few years later, in Nebraska Press Association v. Stewart, he represented the National Broadcasting Company, which challenged a gag order preventing the media from reporting on a murder trial. The Supreme Court ultimately struck down the gag order, ruling that it was an unconstitutional prior restraint on speech. In Smith v. Daily Mail Publishing Company, Floyd represented the Charleston Daily Mail and Charleston Gazette, which were indicted under a West Virginia statute that made it a crime for a newspaper to identify the name of a juvenile offender without permission from the court. And the Supreme Court unanimously struck down the statute, the first in a line of cases upholding what is now called the Daily Mail Rule, or the Daily Mail Principle, establishing that the news media cannot be punished for disseminating lawfully obtained truthful information. And in Citizens United v. Federal Election Commission, Floyd represented Senator Mitch McConnell and argued that the First Amendment protected the right of corporations and unions to spend money on political campaigns. The court ultimately ruled in favor of Citizens United, striking down certain campaign finance restrictions and stating that under the First Amendment, the government may not suppress political speech on the basis of the speaker's corporate identity. Well, Floyd was seemingly involved in every Supreme Court case that appears in my media law casebook. You literally could look at the table of contents, and Floyd's name is associated with every single one of those cases. I just gave you a brief sampling, but any of you who've taken media law, any of you who practice in the area of media law, are nodding your heads and you're saying those are canonical cases. Well, while Floyd was having that influence on First Amendment law, the world itself was changing. The world of journalism and media were undergoing dramatic changes. In the 1960s, when he launched his legal career, mass media in the United States was dominated by a few major television stations, including ABC, CBS, and NBC. Color television was a new technology and was not yet widely available. In fact, as late as 1967, only 15% of American homes had a color television. Well, the 1960s were characterized by the rising popularity and influence of television news. Newton Minow, when he became FCC chairman in 1961, voiced condemnation of the quality of most television programming, calling it a vast wasteland. Yeah. In the 1970s, which some media commentators describe as the worst of times and the best of times for media, the press enjoyed a relatively high level of public trust and credibility. Journalists helped to uncover military abuses during the Vietnam War and exposed a corrupt presidential administration. We might say that Floyd's First Amendment advocacy played a key role in making sure the government couldn't hide its secrets. In the decades that followed, we saw significant changes in journalism and the way news is produced, consumed, and disseminated. Even in the 1960s, the print newspaper industry had been showing signs of trouble, as most newspaper markets underwent substantial consolidation. In New York City, where I know that Floyd grew up, the number of major daily newspapers shrank from 7 in 1959. Imagine 7 newspapers in New York to 3 by 1967. And the decline of newspapers only accelerated over the following decades, with many newspapers today struggling to survive in the face of declining circulation and advertising revenue. The 24-hour news cycle started in the 1980s. Now, I'm telling you all this because many of you are students, my students, and when I talk about pre-internet media, their eyes just glaze over. What, there was something before the internet? How could there possibly be? Well, there was television, there was radio, there were newspapers. In 1980, CNN launched on June 1st, 1980, the first cable news channel to broadcast 24 hours a day, 7 days a week. I tell my students, yes, the television just went to shh at 11 p.m. That was it. There was nothing on. You had to wake up the next morning and hope that they started it up again. Well, CNN changed all that. Their success led to the launch of other cable news networks, including MSNBC and Fox News, creating a constant demand for news coverage and changing the way people consume the news. The 1980s and the early 2000s saw the rise of the internet. I'll admit, having worked at the Washington Post during that time period, that many news organizations were slow to recognize the potential of the internet as a news platform. And more recently, we're coming to grips with the fact that social media, especially Twitter, Facebook, and now TikTok, have become the primary, if not the sole source of news for many people. Now, throughout all these changes, Floyd remained a strong advocate for the protection of free speech, even in cases when he personally disagreed with the content of the speech. Unless you think that after 6 decades, he's finally starting to slow down, I'll note that he recently took on Clearview AI as a client, arguing in cases across the country that the use of public photographs for its facial recognition technology is protected by the First Amendment. And he also recently founded the Abrams Institute for Freedom of Expression at his alma mater, Yale Law School, where he is pursuing an effort to revitalize our understanding of the First Amendment's press clause, which isn't, if it isn't completely dead, is certainly on life support. So please join me in welcoming Floyd Abrams.
Sure. As you see, I follow orders. Thank you all for establishing this wonderful opportunity to talk about the First Amendment. Thank you, Mary-Rose, for inviting me, for the wonderful introduction. I hope you have a copy I can bring home and show off. And thank you for allowing this, letting us, creating this. I want to follow up by way of introduction. I mean, Mary-Rose and I are going to talk chair to chair for longer than I'm going to speak right now. But I wanted to follow up with respect to the sort of differences from a practicing lawyer's point of view and from a First Amendment point of view of what we were doing back in the 1960s and how that changed as the media world changed. When I was a young associate at my firm, our biggest client was NBC. And just as has just been said, more people got their news then, I'm talking 1963, 1967 or 68, more people got their news from television, previously radio, than any place else. Also newspapers, of course, but more people got more and were more affected by what was on television in my fledgling years at this than anything else. And I've just been struck thinking of how different the sort of things that a media lawyer did then than now, how different what we focused on was. One was radio and television have been regulated in a way that the print press is not and has never been. There was a Radio Act adopted, and then various provisions adopted which focused more on television than anything else. And so as a young lawyer, what I was doing was working within the confines of a system of FCC, government, regulation of the broadcast media. And the one thing that we tried hardest to do was to get the same sorts of protection for the broadcast media as had already been established or was still being established for the print press. And so there was then what was known as, and I'm sure you, well, maybe not enough of you are of that age, but some of you will remember the Fairness Doctrine, right? And there are people advocating that now, which I am not one of them. But the Fairness Doctrine basically said if a broadcaster took one side of a controversial issue of public importance, they had to have the other side on. Now that sounds very reasonable, but let's just be clear that that is precisely what they cannot and could not make the press do. The press was free, and is, to decide what to cover, what not to cover. And so in the great Tornillo versus Miami Herald case in the late 1970s, a man running for mayor of Miami was very upset when the Miami Herald not only endorsed his opponent, but pretty well denounced him. Miami Herald had enormous impact on elections in Miami at that time. And he went to court supported by a lot of professors saying they should have to put me on. They should have to give me a chance as well. And there was a statute in Florida which said just that, a sort of right of reply statute, which the Supreme Court said was unconstitutional. And they said it was unconstitutional because they said these decisions are what editors make. This is what newspapers do. Newspapers advocate. Newspapers take positions. We're not going to get involved. We're not going to let the government get involved in the process of deciding what's fit to print and what not. That was a 9-0 decision, to the great surprise of most scholars at the time, a 9-0 decision saying just that in the strongest possible terms. At the same time, the broadcast media had lots of regulations to deal with, which aimed at what Pat Tornillo was saying he was entitled to when he ran for mayor, which aimed at what they were saying was fairness. You put on a broadcast taking a position on a controversial issue of public importance, put the other side on. Well, let me say, that's easier to say than to do, because there are enormous definitional issues. I was involved for NBC and ultimately other broadcasters in a case when ERISA was being considered by Congress. At that point, there was no federal law at all protecting workers who had jobs where they had security in their jobs, which were built into, and when they retired, they would get this and they would get that, something that still exists. NBC journalists worked really hard and did a first-rate and prize-winning broadcast called Pensions, the Broken Promise. And it was about the plight of workers who, under the then-existing system, lost everything as soon as they had to leave or chose to leave the jobs they were in. There was no portability. There was nothing to aid or take care of or protect those workers. Because of the fairness doctrine, NBC had to comply with the proposition. Again, if they were taking a position on a public issue, they had to allow the other side on. NBC said, I said for NBC, that's not what the program was about. We didn't talk about ERISA. We didn't advocate Congress doing this or Congress doing that. We talked about the plight of workers who were deprived of the right or the ability to keep whatever pensions and the like that they had. And the FCC argued the contrary, saying, come on, Congress is considering ERISA. You put a program on which is very much, they said, they didn't say biased, but leaning in the direction of the adoption of new legislation in that area. You have to put on the other side. I don't remember exactly who won. It was a while ago, but I left happy enough to lead me to think we must have won. But I remember a dissenting opinion by a very liberal judge who I respected a great deal, saying, this is all sort of mockery. You're really asking us to believe that this is about some problems in some pension plans? When it's obviously about, and you ought to get credit, your client ought to get some credit. This is a very hard issue to deal with, let me tell you, on a television documentary in terms of getting people to watch it, et cetera, et cetera. I cite that really as just one example of the divergence, the enormous divergence between the rights of the print press and what I will call the obligations of the broadcast press at the time throughout the 1960s and well into the 1970s. Ultimately, the Fairness Doctrine was dropped by President Reagan, and now people don't even think about it, except now, what are we talking about? Of course, we're talking about the internet. And what are we talking about the internet? What is the single issue that's in our courts right now, which is likely to have the most impact on the internet? It's the question of who decides what. Can the internet owners make the decision by themselves to take, as it were, a position? The critical case in a Court of Appeals ruling from Texas, in which the lower court had said, citing the Tornillo case that I mentioned to you, saying that this is just like the press, basically. They're doing journalism, and you're telling them what to put on or what not to put on. And the other side was the internet is not like the press. The internet is different, and it has to be treated differently. And at a critical moment in the oral argument in the Court of Appeals in the Texas case, a conservative jurist asked counsel for the internet entities, are you saying that an internet entity could have only Democrats on? Are you really saying that? Pause. That there is a compelled answer to that question if you're taking the First Amendment position. And the answer is yes. We wouldn't do it. They don't want to hear that. No one would want us. No. You're really saying that you could decide, and again, talking not just about the one case that I mentioned, but talking about the rights that the print press has and has had for all these years, saying, yeah, we created this. You know, it was Facebook, et cetera, but it's our company. We can decide who to put on and who not. That case, as decided by the Court of Appeals there said no. The answer is that a Texas statute which required you to put on the other side, in fact required neutrality, basically, was constitutional. At the same time, Court of Appeals for a different circuit said that a Florida statute doing the same thing was unconstitutional. So we have a very clear divergence in the circuits, and there's just no doubt that one of these days, sooner rather than later, the Supreme Court will be required or will choose, as I think it will think it's required to do, to make a decision about whether internet law, so to speak, should be more like, not the same as, but more like the old television law with obligations on the proprietors, so to speak, to be fair, to do this, to do that, or not. or whether the proper way to view it is through the prism of the press and the like. I cite that really just as an example of where we are. What are the great cases that we're going to have down the road sometime quite soon, not this year, but within just a few years? We're going to have a case like that. What about TikTok? The government is saying, every member of Congress is saying, it seems, that they should not be allowed to continue as they are, gathering all this information about their subscribers when it is owned by China. And China could have access to all that information. The TikTok senior executive within the U.S., pleaded or tried to plead to Congress, we won't do it, we don't do it, we've created a subsidiary, only they have the right to do it, etc. But the reality is that will be, in all likelihood, a really big case in the rather soon future. And again, it will be necessarily about new technology. All the civil liberties organizations that I could name, from the ACLU to FIRE and all the others, are on FIRE's side, are on TikTok's side. And they're sort of alone because no one else is. But that's the current situation on that. And on everything else, I mean, most of the action in First Amendment law in anything like the area that we've been talking about tonight is necessarily about new technology. What's going to happen with this chat stuff that I'm sure the younger ones of you know about and people my age sort of laugh at? But really, what's going to happen? What sort of limitations, if any, is going to be involved there? I mean, I was shocked. I was at a friend's house a few nights ago. Unfortunately, my friend has a son who's in college, so with someone who knows about stuff like this, I asked him to tell me what it said about a book that I wrote. And he asked a one-line question, summarize Floyd Abrams' book called such and such, and I'm not exaggerating. By the time that he finished the sentence, the book called X, there are 5 lines. Mr. Abrams believes this, he said that, the book says that, as if the machine had been reading my book all the time that I was at his house. That company, those companies, those artificial intelligence companies, are going to be absolutely center stage in litigation in the future. It's just unavoidable. And to take the easiest example is libel. We have libel law, of course, and the libel law is very protective of the press and the like because of the New York Times versus Sullivan case. But we do have libel law. And these machines get things wrong. They can't get it right for various reasons relating to what they're capable of doing or trained to do or allowed to do. And so even on the very tentative devices out now, they're putting language on saying, don't rely that much on it. It makes mistakes. We want you to know it makes mistakes, which is something that would never protect a newspaper. I mean, if a newspaper said, here's our product, don't sue us for libel, because we make, that's just the way we are. We make mistakes. So it's going to be very exciting with a new generation of First Amendment lawyers. I'm most appreciative to have had the chance to do the cases my wife referred to them as my children, the cases that I've worked on through the years, and we'll see what we wind up with in terms of the strength of the First Amendment protection about what matters most about the First Amendment, and that is the ability to criticize the government. I mean, that's what the First Amendment is most about, and that's what should not be affected or limited in any way, in my view, by the fact of new technology, which becomes, in a sense, the speaker. So thank you all very much. Again, I'm most appreciative to be here, and I'm ready to take your withering cross-examination.
Well, thank you, Floyd. That was really wonderful and gives us a lot to talk about. As David said at the beginning, Floyd and I will talk for a little while. We have a lot to talk about, but I also want to make sure there's time for Q&A because I want to hear what you care about, and we're just so grateful you showed up tonight. Thank you so much. I have to start, Floyd, I've thanked you several times already for coming, but I have to do so publicly, so thank you. You've been my hero for decades, ever since I was a baby lawyer in Washington. So thank you so much. It's a really great honor. So I thought I wanted to talk about what's going on at the Supreme Court and what the future is at the Supreme Court. So in particular, in the Citizens United case, you might remember that Scalia and Thomas had dueling views of history. So they were looking at the history of the First Amendment, whereas Justice Kennedy, who wrote the majority opinion, didn't really focus much on history, talked about the marketplace of ideas. Now, fast forward in 2023, we had a decision that was on the Second Amendment, the Bruen case. But in that case, Justice Thomas said that he referred to the First Amendment, and he said, we have always decided First Amendment cases looking at text, history, and tradition. And that is somewhat right, but honestly, mostly wrong. Yeah. So I wanted to get your thoughts on what was going on there with what Thomas was saying, and do you think that the court is going in that direction? Do you think the future of the First Amendment is one where the court uses text, history, and tradition to make decisions versus big principles about criticizing the government or the marketplace of ideas?
Who knows?
That's a great answer, right?
That said, I view this as a First Amendment court, very favorable to First Amendment arguments. And how shall I say this? I take less seriously sometimes what they say about how they're reaching decisions. I find their Second Amendment historical analysis totally unpersuasive to me, treating muskets like machine guns, as if there's no difference in terms of protection at all. So in a less academic, I don't mean it critically, but in a manner which more reflects my thinking about where I think they want to go and will wind up going, I think they will continue to be a very protective First Amendment court. I want to put libel to the side for the moment.
We're doing libel next.
Yeah, right. But I think in general, they like to think of themselves, and they do think of themselves, and for the most part, they do act as if the First Amendment should be read broadly, very broadly, to protect whatever the instruments are of communication. And I think they're likely to continue that. Now, as to whether they're going to continue it sort of wholesale will necessarily depend on the nature of the instrument and on the topic, privacy. We really have no idea where this court is going to go in assessing competing claims of privacy and the First Amendment. There's no reference to privacy in the Constitution. It's judge-made, although they would say, more deeply imbued in our history, but you certainly don't find it if what you do is to read the Constitution, including the Bill of Rights. But no one's against privacy, and people rightly, and they rightly take it very seriously. What are they going to do with new sorts of computers which have enormous ability to penetrate easily into people's identification from airplanes, from far away cameras, enormously far away. There were cases, movie star cases mostly, where the movie stars object, the pictures into my apartment. And yeah, there are cases, not Supreme Court cases, but there are cases saying, yes, there's a right of privacy in your own abode. And so far, I'd say the law is that devices which allow you from half a mile away to do that can be limited. That is to say, the privacy claim will win in a case like that. But how about a lot closer? And is that the way we're going to decide cases? By distance? I'm citing it only because it's so difficult. And among other things, because of that, I find it so difficult to predict where they're going to come out. If Justice Thomas means what he says, I don't think he's going to find a right of privacy of anything of the sort we think of privacy to mean around the time of the Revolution and the beginning of our nation. In part because people couldn't, there were no cameras. One of the things I learned representing this artificial intelligence company is that the first cameras that non-photographers, photographers for a living, photographers in the old days with like a blanket over their head, the first cameras that individuals could carry is the very end of the 19th century. 1890 this, 1890 that. And you read the press, and I did it for this case, you read the New York Times talking about how people are very angry at what they called Kodak fiends because they take pictures of women on a beach without their permission, even if it makes them look bad, and without their consent. That never went to court, fortunately, I would say. It never went to court. But the ability to intrude upon, what most people would think of as privacy is going to be so tested, and I would say sooner rather than later, because the technology is there. My client just basically takes photographs off the internet, off the public internet, of which they now have 10 billion photographs from the internet. And their clients now are the police, FBI, and the like. I mean, the one witness that we had, we wound up not using him, for a case I was in, was an FBI agent who deals with children who are kidnapped and terribly mistreated. And the FBI finds what my client offers very helpful. The other argument is look at communist China. I mean, look at places where there are cameras everywhere and people can be traced everywhere and are. Again, I simply cited as an example that as the technology gets better, we're going to have a whole new raft of decisions that have yet to be made, and with not really a lot of guidance in the cases that we have at this moment.
Yeah, just to bring it back to the chat GPT that you were talking about, I was reading how Getty Images has just sued Stable Diffusion AI, and if you've been following this, Stable Diffusion is creating images used after having scanned Getty images all over the internet, and so Getty's now suing. So there's going to be, I think you're right, there's going to be a lot of litigation coming from this AI, which necessarily to be effective needs to get fed information. Yeah.
And I think there'll be enormous sympathy for the privacy claims, and yet it'll be a very hard case on both sides. I mean, usually we say First Amendment law, I'm telling the truth. I have a picture of all of you. Suppose I had it here, and, I've got it. You're going to pass a law? So it's a very unpredictable, except that it's very predictable that there's going to be a lot of litigation about
That's what's predictable.
things like that.
Well, Floyd, you mentioned defamation law, and I have heard you speak many times about New York Times v. Sullivan and the lot of noise that's being made about that decision. Particularly, Justice Thomas and Justice Gorsuch have both raised their concerns, to say the least, about that decision, have suggested that the court might want to revisit the protections of the actual malice rule that the court established in Sullivan. So I wanted you to give your analysis of what you think is going on, and maybe in that, talk a little bit about the different arguments. So Thomas's is making arguments along history, he says, and this tradition and text, and whereas Gorsuch is focusing on changes in the media, which dovetails nicely with the comments you were making. So what is your reaction to what they're saying, and do you have any predictions about what might happen?
See, I just think Gorsuch is sort of factually wrong. He doesn't understand journalism. He doesn't understand what journalists do. What he understands is that he doesn't like it. He doesn't like the results. And he views it as biased and far left liberal orthodoxy. That said, I continue to think that they're, with one exception, likely to continue with New York Times against Sullivan in more or less its present form. That is to say, that when you write about a public figure and what you say isn't so, that you're still not liable unless you knew it wasn't so or you suspected it wasn't so. What the court has called a high degree of awareness of probable falsity. But it's a crap game trying to predict these things. I mean, I read all of, just when he was nominated, Justice Kavanaugh's First Amendment opinions. They're pretty good from a First Amendment perspective. Is he going to change his mind or feel freer on the court, not to continue with the law as it is? We don't know. My guess or surmise, maybe my judgment, is that they're not ready to take that hit, and that they'll let this stay at least for a while more. But it's very hard to predict. I mean, I don't think anyone could say that historically anything like New York Times versus Sullivan was what our founders had in mind. But, again, everything is so different, and if you take history into account at all, history in its changing way, I continue to think, maybe I'm just hoping, but I continue to think, as you hear the incoherence, that they're not ready to do that just yet. I'd also add that it is rich in irony that the case in which they might have the chance to do that involves Fox News, which is clinging to New York Times versus Sullivan as if it was a child of theirs. So it would be amusing, at least, if Fox loses and Fox appeals as they would and seeks Supreme Court review on the ground that they didn't get enough First Amendment protection.
Yeah, we were talking about that at lunch today. So Floyd came to the law school today and attended a class and had lunch with some students, and we learned that you were the lawyer who helped establish the neutral report privilege. And I was wondering, if not everyone here is a lawyer, if you could talk a little bit about what the purposes are of the neutral report privilege and how Fox is trying to use that privilege.
There was a case, I represented the New York Times in a libel case brought by 3 scientists who complained about the Times' coverage of essentially their work. The case related to the degree to which DDT killed birds and the consensus at that time, and my guess is still now, but the science was that DDT was terrible for birds and was the cause of bird population getting smaller. And 3 distinguished scientists were named as individuals on the pro-DDT side, so to speak, is the way it was characterized. They brought a lawsuit against the Times because the National Audubon Society had published an article about the case in a way which made it seem as if they were denying that DDT had anything to do with the diminution of bird population. And I represented the Times in the case, and I was saying, how can the Times be in trouble if an entity such as the National Audubon Society writes something and the Times says the same thing, or writes about it in a way which assumes the truth of what the Audubon Society did? And the court ruled in our favor, and it basically said, when you're just engaged in sort of neutral reporting, Times didn't make up the story, about what a responsible speaker or source had said about a matter of public interest, that you shouldn't be responsible in libel law. Now, Fox is trying to say that that's sort of like what its situation is. I don't even know how you put pen to paper making that argument. But I do think, and I was saying yesterday, and I've been thinking about it since, and if the question is, Is the press protected, and should it be protected, if it reports defamatory falsehoods of, say, the president? Suppose it had been the president himself, President Trump, say, who had said these things that Fox News had other people saying. Should a newspaper or broadcaster be in trouble for quoting exactly and accurately what the president said, even though it's false? And maybe even if they think it's false. That's in the ballpark of what Fox is trying to say. Fox is damned because of its own internal writing and what people said to each other, and everybody kept notes, and so it's hard to make it as innocent as I'm now portraying it. But I do believe that journalists need to be protected, ought to be protected for accurately reporting on defamatory charges made by people in power. That's not the law right now, but my guess is that's where it may wind up.
Do you have a prediction for what will happen at trial in this case?
It's really hard to see Fox winning in front of a jury. The judge has already ruled that every single charge that they made against Dominion was false. The judge has ruled that it is, and in capital letters now, judges don't write in capital letters, in capital letters, that it is crystal clear that the charges against Dominion are all false. Now that doesn't answer the question raised in New York Times against Sullivan, assuming Dominion is a public figure, then the question is, what was the state of mind of Fox News, when they did their, so to speak, reportage? They don't have a whole lot of arguments, but that's the one they'll certainly be making most. And they always start, as I think they should or almost have to, with the president said this, and these people were saying the president is right. Don't blame us because we put them on again and again. So it's a hard case for Fox.
Well, we'll be watching that in the not too distant future. Another issue I wanted to talk to you about was the publication of national security information. And so you defended the New York Times in the famous Pentagon Papers case. The United States is still, as I understand it, pursuing its prosecution of Julian Assange for publishing leaked information on WikiLeaks. And so I don't know if you and I have ever talked about this, so I'd like to hear your view on what do you think about that prosecution? Should the U.S. be bringing that prosecution? Does it pose a danger to the so-called traditional media if that prosecution goes forward and is successful, I guess I should add?
Let me say first that the information that is in the newspapers today and is being reported on now is more secret than anything I've dealt with. That is to say, the leaks in cases I've worked on. I mean, the Pentagon Papers was really an internal report prepared at the request of Secretary McNamara during the war in Vietnam, of how we got into the war. And you may think a little late to ask, but how we got into the war, and what our choices were, etc. And one of the reasons that we did win the case is that the judge, our trial judge certainly, and I think that the majority of Supreme Court justices who read any of the material just didn't think it was all that risky. Today's information, I mean, they don't know what to do. I'm sure. I mean, you would know.
You mean the government doesn't know what to do?
Yeah. I mean, they're saying,
trying to figure out who's leaking.
Yeah, the one thing
Yep.
they're not quite saying yet is don't believe us, or, I mean, someone must have said internally, can we say we were just speculating? Can we say, like a chat, a back and forth within the Defense Department? Wouldn't it be a good idea if Israel did that, or if the Russians didn't do that? I don't know if this stuff, today's stuff, is subject to that. Assange has always given me a lot of trouble. I feel as if I'm supposed to be on the First Amendment side, and he drives me crazy. So he's, he released, 50,000 confidential documents from American diplomats around the world. As to most of them, we had promised our ambassadors confidentiality to workers protecting human rights and others who were complaining about their totalitarian government. And he released all of it and didn't read it either. Didn't read all of it at all. He released every single one of those 50,000 documents. Now, a number of years have passed, and it may be that, as is often the case, the government exaggerated the risk of what would happen. And one thing they probably know, if anything bad really did happen. I mean, as opposed to what could happen if it's released. In any event, I think Assange has been irresponsible and dangerous, and I hope they drop the case because the Espionage Act under which he is accused is phrased very broadly and very dangerously, and a verdict against Assange, as much as I disapprove of what he's done, a verdict against him could be used in later cases against journalists who do nothing more or less than what our best journalists do, which is try to find out what's going on within the government. And since almost everything interesting is classified, you're always in the area of classified information. So I hope he gets off, but I'm pleased to criticize him.
That's fair. I think that's very fair. So you've represented Judy Miller, for example, in her claims for reporter's privilege. I'm wondering, and of course you represented the press in the Pentagon Papers case. Do you feel like the actual sources, the leakers themselves, the government employees and the contractors should have any First Amendment rights, perhaps to make it the most plausible? Maybe they're revealing government wrongdoing. I'm causing you pain, I see. How do you feel about this?
Let me say first that one of the interesting divergences here on policies like this is between the U.S. and England. We have much more in the way of First Amendment rights for the press and others who talk to the public than is true there. But what they allow is a defense of public interest. They allow the leaker to defend leaking. And we do not allow this, to say, yes, the law says this, but there was such a good reason to leak this information. or that would be phrased as, there was such a public interest in the public knowing what we were doing about this or that, that they wind up really, and indeed his lawyers have asked for the application of English law, which to any First Amendment lawyer is sort of bizarre sounding, since half the time we're talking about how much more protection we have that they do. And any time an English newspaper comes upon something which is really hot stuff, and they have an American subsidiary, they publish it here. And that has been the case, and it remains the case. People on trial in England for making it available, and the English get deterred sometimes if it's already out, and nothing bad happened. That's another thing. They don't tell you if really bad things happen. I mean, I think it would leak on purpose from them if it could be shown that Assange, for example, what I was criticizing him for, had resulted in the deaths of people who had confided in the U.S. ambassador in this or that country. I just think the government, there's nothing they'd like more than to show the impact of what Assange leaked, and they certainly haven't tried to do that yet. So that's all I can think of.
Okay, good. Well, David mentioned in his remarks that you are funding a new initiative at Yale to look at the press clause. And I want to ask you, do you think that we could ever define the press? I know that the initiative is purposely not going to focus on that to start with, but do you think that that's ever possible? Like, and what would you do with, say, Fox? Or what would you do with Fox? Like, do they count as the press? Do you forfeit if you don't act neutrally and responsibly? Do you have to be neutral to count as the press?
I mean, I wouldn't think you have to be, a good person to be press. I don't think you have to protect your sources. I think people that gather information and disseminate it to the public, as a general proposition, are press. Now, the subject comes up. Do you have to be paid for it? Do you have to be an employee? It came up last week in congressional testimony of someone who was quoting, now you'll have to give me the language, Substack, quoting someone who had been a regular professional journalist who now has his own website on Substack. And a Democratic congressman said he's not a journalist. He doesn't work for anybody. And a number of journalists said, I mean, they happen to be left-wing. I only mention that because that's probably why they were speaking, because they liked the speech so much. But that doesn't make them wrong. A number of journalists said, we can't make a decision about who is a journalist simply based on whether they're employed. Well, most of our states now have shield laws that protect journalists about revealing confidential information. Not all, but just about all states now. And our Attorney General has said the Department of Justice will no longer seek confidential sources from journalists, period. Attorney General Garland. That is the policy of the United States right now. But that said, it doesn't answer your question of who gets the protection. All these shield laws try to define who is a journalist. And they all have regular employment, gathering news and disseminating it to the public. Otherwise, it's anyone, or that's the risk. It's a very dicey, very difficult topic of who is a journalist and who would get more protection. And it was very interesting to me that I mean, there's a political side to this too, but that it was the Democrats who were saying he's not a journalist, so don't treat him, so to speak. Don't honor him as if he were an independent, blah, blah, blah. And on this one, the Republicans, I think, were probably amused by that answer, but also, you know, of the view that shouldn't be the test. But it will be very hard, and yet you can't have a privilege without an answer to who gets the privilege. And if it's not a privilege, if it's just a right, then everyone has it. And particularly in the national security area, that's not something I think anyone, certainly no congressperson, would be in favor of.
Well, one more topic I want to ask you about before turning it over to Q&A, so get your questions ready. And it's one that I have to ask you about, which is about what's going on in higher education right now. There's a lot going on. My class that David mentioned has spent the entire semester talking about the First Amendment in education, and we need many, many more classes to get through everything. But today you attended my class where we were talking about speaker policies, and I think many people have heard about what happened at Stanford recently, where the students shouted down a federal judge. And I was wondering what you think is going on. Why are the law students reacting in this way? What is their relationship with the First Amendment?
Look, I don't think shouting down a speaker is protected by the First Amendment. Or to put it differently, I think a university has the power to punish students who do that. But that said, I mean, could we have a law in this sort of area? That would be a very chancy thing. In part because we're talking about conduct which is so sort of fraught, that conduct and speech often at the same time, often in the same context. I mean, unruliness is not protected by the First Amendment, and the only reason universities shouldn't deal with that is that the price of enforcement may be too high, but they're allowed to under the law, I'm sure, about things like that. We do have a number of groups of students at our great universities and otherwise, often minority, often very politically engaged, who wish to be heard. And the question, I think, is how can we assure their right to be heard without allowing the sort of juvenile nonsense that went on at Stanford, where a federal judge comes to give a speech and the kids are yelling, and a DEI person winds up more or less, she's supposed to, or people thought she was supposed to be the university representative there. She winds up giving a speech aimed at the judge instead of at the students. It's a very difficult area to deal with. It has First Amendment implications, ramifications, but that's not what it's mostly about. It's very important to find a way to let students speak and speak out. I mentioned in your class that I remember at Notre Dame a few years ago under President George W. Bush, the Vice President Cheney came to speak at the graduation. He was invited by Notre Dame to be the speaker. And over half the female students at Notre Dame walked out. I mean, that is, in my view, an entirely proper, let alone legally protected, but a smart way to have everyone noticed too. I mean, that was a story, and they were rightly praised. But you know, the reality is that yes, that on one campus after another, groups or individuals who share the same views are making it difficult for almost always conservative speakers or speakers whose views are really contrary to what younger people in particular seem to have. And it's going to be very, very hard to deal with. And your class and you dealt with a lot of procedural things that can be done to try to lessen the likelihood of disorder in the classroom. But I mean, however one does that, it still has to be done in a way that allows really the widest range of free expression by students, so long as it doesn't interfere with the educational mission of a university. And if a university invites someone to speak, the chance for the person to give the speech.
Well, thank you, Floyd. I could follow up with many questions, but I'm going to let you all now pose some questions. I think we have some audience members queuing up at the microphone. So identify yourself first and then give your question, please.
Hi, my name is Deb Ikat. I'm a faculty member in the Hussman School of Journalism and Media. And I really wanted to thank you for this engaging discussion of not only the future of the First Amendment, but the past, present, and the future of the First Amendment. My question relates to the racial reckoning we are going through in this nation and beyond. And as you know, since 2020, when Floyd was killed, every school, every entity in this nation now has a diversity director, diversity and inclusion initiatives. And as you know, some of those diversity initiatives are in tension with academic freedom. And so much so, some people are saying that it affects and disrupts the First Amendment. What would you feel is the future of the First Amendment, considering that we are dealing with these tensions? Thank you.
Yeah. Better question than any answer I could give. We're going to continue to have tension and great difficulty in resolving the competing interests, the need, perceived and real, of assuring a free level a sweepingly broad level of communication. And I would say, if I had to pick out, particularly at a state school, given that the state is the government, that it's all the more important that speakers be able to have their say, and at the same time, that students have the opportunity to participate in the process in some sort of, rational way. It's not an answer. I mean, there's no there's not going to be any easy answer to how to resolve the tension between students who feel that strongly up to this point. I mean, we can't let them scream and keep the speaker from speaking. Is there some way to have an alternative way that would satisfy them to engage in free expression and serious, by serious I mean seriously critical expression of speakers with whom they differ? I don't have any more answer to that. The question is one that the universities are going to be plagued with, because there are never going to be easy or even accepted by all answers, however much I might agree with them. For example, I mean, I liked the letter of the Stanford president. That I agree with it, and it's a strong, powerful letter. I recommend to you about, and her looking back. She's the dean, I should have said. But no, it's not going to satisfy the students. And are there things we can do to make the students, or to persuade the students to accept less than what they want? I don't know the answer to that, but we have to try.
Thank you.
I'm Ray Falk. I'm a graduate of the university several times over and a resident of Chapel Hill. My question relates to the Citizens United decision. The philosopher John Rawls in the latter half of the 20th century said that for a functioning democracy, the most influential people and the least influential people should differ in influence by less than a factor of 2. How he measures that's another story. But it seems that Citizens United, which has been characterized as corporations are people too, and permitting dark money, is unbalancing that, making that factor up, from a ratio of billions to 1. And I'm wondering how that sits with you as the attorney who won that case in that direction.
Citizens United doesn't deal with dark money. We do have some dark money, and there's no bar in the law, as I would write it, in requiring more exposure. I mean, I do think that the trade-off for more speech ought to be more information about who's speaking. That is not where we've gone so far. Citizens United, to me, was the case which, in a way, implicated most of what I spent my life doing, my professional life doing. Almost all of my clients have been corporations. The New York Times, NBC, every entity I've mentioned tonight is in a corporate form. This university is a corporation. Our art museums are corporations. I mean, all of them are. I had a little case once I was proud of for a while in the investigation of Bill Clinton. There was a subpoena served on a bookstore in Washington for the bookstore to reveal what books Monica Lewinsky bought to give him. The bookstore is a corporation. And one doesn't always think of, books are books, but we don't always think of bookstores as protected by the First Amendment. They argued, not my case, they argued that they shouldn't have to reveal who buys their books, and they won. So I'm not afraid of corporations. I've just lived with them all. I mean, I've lived in so many of what I do for a living. The dangers here, I think, the biggest danger is that the public doesn't know and can't know what's happening. Now, the other big danger is one which takes a lot more than anything in Citizens United, and that's the vast differences in wealth and power in the country. We could deal with that with taxation and all sorts of economic ways if we had the will to do it. But I don't think we should do it by limiting speech based on how much you are willing to spend to get the speech out. And the example, Citizens United itself, what is it? Citizens United is a conservative group that did a sort of a hit job movie on Hillary Clinton, why she shouldn't be president. That's what the case was about. Now, by my lights, there's nothing more protected than that. I mean, commentary on someone who might be the president and who then, Obama beat her for the nomination, but who then looked like she'd be the likely Democratic nominee. And the fact that it was a corporation seemed to me something that ought not to have been an issue in the case. To say it maybe more directly, if you want to go after the money, go after the money. You want to go after the power. I'm not saying it's going to happen. I'm just saying that if the problem is too few people have too much power, there are ways in a democratic society to deal with that, but it ought not to be by limiting speech.
Thank you.
Larry Keith, journalism class of '69. I echo the thought. Mr. Abrams, thanks very much for sharing your time and expertise and intellect with us today. Just so happens I have a follow-up to the Citizens United question, and I wondered what you thought about this sentence, that the decision also provided the legal justification that was used by the D.C. Circuit Court of Appeals in the Speech Now case to unleash, their words, super PACs on our political system. Your thoughts?
I think there's some truth in that to unleash having super PACs. Super PACs are also corporations. I mean, they're one issue corporation. It was legal before Citizens United, but it didn't happen that often to have the equivalent of super PACs. My view is that the important thing is for us to know who's speaking, and if one wants to deal with issues of inequality, of which we have so many, that we ought to, if we're talking in theory, we ought to address them. Now, if you say it's just impossible because the people have too much power to address it, I mean, an aroused public, the public was never aroused by Citizens United. Faculty members around America were. And indeed, there was a recent vote by some faculty members. It's the single worst decision in Supreme Court history. People, I mean, these people who read cases about discrimination and about slavery and the like, saying that. So I hope none of them are here. But do we have a last question? Or
Yeah, let's have one
Yeah,
more
yeah,
one
yeah.
more question. Sorry, it's getting late. Thank you.
Good evening. My name's Juliana. I'm a student here at UNC, but I also teach a course called Law and Information Technology. And I'm a big fan of your podcast, Speaking Freely. It's quite an excellent podcast. I definitely recommend. But on your podcast, you ask a lot of your guests this question. Given the centrality and the degree to which people receive information and participate in expressing their views on social media, are we better off from a First Amendment perspective and social policy perspective with 3 networks and fewer modes of communication, or the broad network of internet communication that we have today? Your thoughts?
You have to be a certain age to ask that question.
Yes, probably.
We lived in a more civil society then, all those years ago. I won't say, I just refuse to think that the answer is it might have been better back then, where fewer people were speaking, almost always saying the same thing, and you know, hardly ever engaging in, you know, any of the sort of, you know, really good. I mean, if this were a newspaper question, I'd have a lot more problem with it, because newspapers did then, and the best ones now, the sort of high-level investigative work that would at least want to think that, well, at least we have that on our side. But no, I don't really think that we were better informed with 3 gray-haired, male, well-spoken, Middle West Americans telling us that's the way it is.
I'm going to invite Dean Reese to the podium to close out our colloquium.
Thank you, Professor Papandrea, and thank to our distinguished speaker, Floyd Abrams, for coming here. That was an amazing, amazing history lesson, but also looking into the future and some of the controversies, some of the issues coming up. And I just want to thank all of you for being here tonight, and especially the School of Law and the Center for Media Law and Policy for putting together this event and the opportunity. If you don't know about the work that is done by the Center of Media Law and Policy, I invite you to find out more, because they have amazing speakers, events, opportunities, activities going on campus. Specifically the co-directors and co-chairs, Professors David Ardia and Amanda Reed. Amanda over there. So thank you all for organizing this event and for the work that you do on a daily basis. And thank you all for being here. Thank you.